The centerpiece of the SEC's new marketing rule is the new definition of the term advertisement. The definition is divided into two separate prongs. The first prong deals with communications made directly or indirectly by the advisor. This is mainly a modernization of the existing definition. The second prong deals with communications made by third parties that are compensated by the advisor. This is brand new. Think of the first prong as answering three separate questions. First, who is making the communication? Second, what is the purpose of the communication? And third, how is the communication made? Who? A communication by the advisor is considered an indirect communication in two different scenarios. The first scenario relates to a communication by a third party that has been created in whole or in part by or in collaboration with the investment advisor. Marketing materials prepared for a placement agent or solicitor is one example of this type of indirect communication. Another example would be materials prepared by the advisor for inclusion in a fund of funds offering document. The other type of indirect communication relates to materials prepared entirely by a third party, but used by the advisor for its own purposes. For example, if the advisor posts on its website a hyperlink to a favorable press article, the content of that press article could be considered an advertisement by the investment advisor. The next element in this prong of the definition relates to the purpose of the communication. Here, the purpose must be to offer investment advisory services relating to securities. Nothing new here. This element goes on to say that the communication must involve one of two types of offers, either an offer to brand new clients or brand new investors in a private fund, or offers to existing clients or existing investors of new or additional services. This is really a clarification rather than a change in our understanding of how the existing rules work. The final element of this prong of the rule relates to how the communication is made. In order to be an advertisement by the advisor, the communication must be made, with one technical exception, to more than one person. Again, this is not a change from current law. What is different is that the rule now specifies that all types of communication are potentially advertisements. So it's now clear that oral communications to more than one person can be advertisements, and all types of social media communication, whether existing or future, will also be covered. Before we turn to the second prong, let's cover two exclusions from the first prong. There's an interesting new exclusion for extemporaneous live communications. Extemporaneous means there can't be a script and there can't be any accompanying written materials. Live means it can only happen once. If an advisor tapes a live broadcast and rebroadcasts it, that would cause it to be an advertisement. There's also an exclusion for the content of communications that are reasonably designed to comply with regulatory requirements. An example of this type of exclusion would be an ADV brochure. The second prong of the new definition deals with testimonials and endorsements if they're paid for by the advisor. This prong relates to the fact that the new marketing rule consolidates the old cash solicitation rule into a single comprehensive rule. A testimonial is any statement by an existing client or an existing investor in a private fund. An endorsement is a favorable statement by any other third party. In either case, if there is direct or indirect compensation by the advisor, then these sorts of communications are considered advertisements. A few things to note about this rule. First, the concept of indirect compensation is a significant departure from the old cash solicitation rule. Indirect compensation refers to any form of benefit conferred by the advisor on the third party making the favorable statement. So this could be non-cash compensation taking the form of gifts and entertainment. It could be fee breaks on products offered by the advisor. It could be cross-referral arrangements. Any type of benefit will count as potential compensation. There is a de minimis exception, which is defined to mean amounts having a value of less than $1,000 a year. However, this is only a partial exemption, and therefore this new indirect compensation concept can be a real trap for the unwary. A few more points to note about this second prong. First, unlike the first prong of the definition, this prong captures any type of communication, including one-on-one communications and extemporaneous live communications. This really isn't surprising because this prong of the definition is intended to capture and regulate the conduct of placement agents and third-party solicitors. The next element to keep in mind that differentiates this prong from the first prong is that the favorable communications don't need to be limited to communications offering investment advisory services relating to securities. Any type of favorable statement about the advisor or about the advisor's personnel could be considered an advertisement under this prong if there is direct or indirect compensation. Finally, in a very significant departure from the cash solicitation rule, this new prong explicitly picks up communications made to prospective investors in private funds. This is an intentional departure from the old cash solicitation. That's all we have time for today. I will note that the SEC's explanation of the new rule devotes 50 pages to explaining the nuances and details of this new definition, and I encourage you to review it carefully.